ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. So today is a very wonderful session. The thing that very important guest is arrived. Srimati Nandita Batra, who is a practicing advocate before the Honorable Supreme Court of India. Earlier, she was a law professor at the prestigious National Law School of India, University, Bangalore. She had a wide teaching experience and have a research experience on various issues. Particularly, she is completely in having an expertise in the medical laws and related health laws. So, in this juncture, I had requested Nandita Batra ma'am to take up a session on a women empowerment law, which she had agreed, and she agreed for the session, particularly with the POSH Act, Prevention of Sexual Harassment at Workplace. So, as she is a master, so in the subject area, so let us welcome our guest, Srimati Nandita Batra, to a wonderful session on prevention of sexual harassment at workplace. Thank you so much, ma'am, for coming here.
Thank you, Purushottamji, for a very kind introduction, a very generous one. I'm glad to be a part of this legal aid awareness program that you're conducting online. So what primarily I'll do is I wanted to discuss about the POSH Act and the related laws. But before I did that, I wanted to have a kind of overview that the audience has about sexual harassment. I just wanted to question the audience, which is there. What do they mean when they hear the term sexual harassment? I understand today that we are not in 2013 when the law was made. We are today in the age of internet where you have a lot of examples. You've seen, we've all walked through and lived through the Me Too movements. There is currently a Me Too movement going on in the Malayalam industry with the HEMA committee report being out there. But I just wanted to get a sense of what people generally think is sexual harassment. I'll just try to broaden the question and perhaps that I can take some answers from the audience. Do you think that for sexual harassment, there must be a sexual act which must have been committed? Do you think only if a sexual act when committed, that is only amounting to sexual harassment, or is it something more than that? And why is sexual harassment a problem? The third question that I would have for you in the beginning is because, Purushottamji mentioned about POSH Act, but I want to think a little aloud and I want to question the audience. Do you think sexual harassment is a problem limited to workplaces? And perhaps with this some knowledge, we can perhaps then go ahead. Anyone, who would want to volunteer and answer any of the three questions that I just posed. Purushottamji, if the audience doesn't answer, I'm going to ask you to answer these questions.
Definitely. I am there to question as well as to interact with the session. My first question is with you that
no, I have
you
asked these
see.
questions. Anyone from the audience would want to answer these.
Okay, if the audience take initiative to raise a question, voice out. So okay, Dilikar Ramachandra Rao. Yes, sir. You want to ask some question? Dilikar Ramachandra Rao?
No, sir, no.
No, you want to ask some question that what exactly the sexual harassment means. Do we consider that the sexual harassment is only happening at workplace, or the definition which is beyond that?
No, the purview,
Okay,
not
thank you.
The question that I have for everyone is, do you think, first, what do you mean by the term sexual harassment? First, you have to clarify. Then I'll talk about the parameters. We first need to understand the animal that we are talking about. So when I say what is the elephant in the room, I want to ask the question, do you understand that this animal is an elephant in the first place or not? So what is the topic or the theme about? What is sexual harassment? Is sexual act mandatory for an act to constitute as sexual harassment? Let me give you an example, okay? Maybe I'll give you some more thinking points and then perhaps someone from the audience would want to come. A says to B, let's say not at the workplace, let's say in open. I'll use a wording. I'll be talking in English, so but I had a Hindi example in my mind. You look like the cream of the butter, and I love ice creams. I love butter. A comment made by a man to a woman. Do you think this is sexual harassment?
Yes, yes.
Yes. Okay. Another example. A asks directly B. C, whatever it is. Are you interested in a one-night stand with me? Is it sexual harassment?
Yes. It is.
Yes. A shows certain pornographic images to B. Is it sexual harassment?
Yes.
Unsolicited images. So you understand that sexual harassment is not limited to a category of cases where there is an explicit demand for sexual activity. It is not always an explicit demand for sexual activity. But what is important when we talk about sexual harassment is that there is sexual intent. And the question then is, why is it a problem? You know, we are all human beings. We're all sexual beings for that matter. Why is it a problem? Why sexual harassment is a problem? Why do you think sexual harassment is a problem?
Because it annoys the other person. It annoys the emotional aspect of a being. As it causes inconvenience, a kind of irritation, a kind of what we call a kind of a humiliation. See, all emotional facts will crop up, and the person, particularly the female gender, will feel humiliated, and it will lead to the emotional distress.
Anyone else? Why do you think sexual harassment is a problem today? Let me give you my overview. This may not be the perfect answer. You may have your own thinking points on it. Yeah, please go ahead. I can't hear you. Can you please repeat?
Rajesh sir, please speak to ma'am. Hitesh, you want to speak?
Hello.
Yeah,
Yes,
please.
Hitesh. Hitesh? Okay, please continue, ma'am.
All right. So, see, we are living in civilized society.
Me?
We have, please go ahead.
Can I speak?
Hello.
Can
Good
I
evening,
speak?
madam.
Yes, we are hearing you, sir. Go on. Please proceed.
Good evening, madam. And my question is, usually the women employees which who are being in the ill-motivated the mentality, they are going to create a lot of hectic for the employers. But whenever they want to gain something in a backdoor step, they'll keep on charging differently and make them
Hello,
difficult to get into the problems, madam. For that, what is the solution?
That I haven't even come there, but if that's the thinking, I think we need the gender sensitization program. Why do you think women, for their advantage, would do that kind of activity? Are all women same? When you say not all men, are
No,
all
no,
same?
madam. No, I haven't taken the word that every woman. Yes, we do have all the women with the courageous and all the good the will only.
Your question, I haven't even come there, but to answer your question, what if, it's used as a weapon and not as a shield? There are provisions in the law. In fact, the law that I'm going to discuss is the only law which provides punishment for frivolous complaints. Men make complaint about women all the time. no frivolous complaint action can be taken. But employer has the power, if the complaint is found to be frivolous or vexatious or malicious, that the action can be taken against the erring employee. So there are provisions on that. See, every law that you have, every law will be misused. But to say that women are the ones who are going to misuse the law, therefore let's not have the law in the first place, that expressly tells us the kind of society that we have. See, the question that I asked was, why do you think sexual harassment is a problem? It's particularly because of the patriarchal mindset that we have. It's years of oppression that women were made to undergo, that they were confined to their homes. We have a lot of discussion in the political history on the public-private divide. And if I can just summarize it, women to be kept at home, do the household work, and men go outside. The political is there. And this serve, be it the economic theories of labor or be it the sociological justifications that have come up, everyone regarded this as a beneficial arrangement. But what happened because of this the purportedly beneficial arrangement for the man was that he was thriving on the free labor of a woman. And it is when women started demanding their rights that, we are human beings. And, we have the same rights as you should be having. It's not just the world of men, it's the world of human beings. That's where when this awareness comes around. And despite the constitution saying that, yes, we the people of India constitute, it is not we the men who make India. It is we the people, which comprises men, women, and other genders, and everyone else, in this country, that when we constitute this political, we realize, yes, there were these historical injustices. The patriarchal mindset has still not changed. And if I can go back to B.R. Ambedkar, there was equality on law, but not in the economic and social life. It was not just true for the caste system. It was equally true when it came to the gender equality. The problem is we have sexual harassment as a problem because gender inequality is a fact. Patriarchy is a fact. It is not just important for us to say that women have the same rights as men. And therefore, when we said that women have the same rights as men, there were a lot of troubles in the form of laws, which were purportedly gender neutral laws. But the fact that they were made by male, it had its own bias in those eyes. So I'll just take you one example. If some of you are lawyers in the room, perhaps you would have definitely read this case, which is the case of your IFS officer, wherein the law was that if you are an IAF officer you have to take prior permission before your marriage. If you're married, then you're not allowed for a particular position. For 5 years, you cannot marry if you join this position.
Yes, ma'am. Yes, ma'am. We are aware of.
I'm talking about the landmark cases that happened in 1970. So I'm saying, yes, there is equality on paper that, yes, women can come and work. But is the equality actually in practice? So when male make laws, you may not be aware, you may be doing benefit to the people. But unless and until it is looked from a woman's lens, these problems will continue to be perpetuated. And that is why it was, women were given only equality, if I can say, on paper, not in reality. And one of the reasons when they tried to exercise even this formal or constitutional equality that was given to them, the societal conditions were so bad that they perhaps could not have lived as a free citizen of the country. And one of the problems that women were facing from exercising their political, constitutional, economic rights were the problem of sexual harassment, the problem of male gaze, the problem of stereotyping in every sphere they do. They go to the school, the teacher makes the comment if she is a female student. She's a colleague, she gets the same kind of comment. She goes on the road, eve teasing, nasty comments, as if, she has no dignity at all. And it is because of this that, India has seen certain kinds of movements. I talked about these cases. I'll talk about another case, where this male gaze, and in this case, the male gaze was coming from the Supreme Court itself. So not even the judges were immune from this patriarchal blind that I'm talking about. Let me talk about this case, which again you would have read, Tukaram versus State of Maharashtra. I'll not go into the finer niceties of or the details. It's a case on 376. Which led to open letter to the CGI, the then CGI. In this case, there was a tribal woman, who claimed that she was raped, and she was raped in a police station. The trial court had convicted, the trial court had acquitted, the High Court had convicted, and then the matter reached the Supreme Court. Supreme Court acquitted both the accused, and the reasons that it gives are atrocious. It should be behaving in a particular manner. She did not cry. She did not resist. This is how women are supposed to behave. A good girl, a bad girl, a Western girl, an Indian girl, what not, you will find a lot of stereotyping. And then the way the Supreme Court had stereotyped women in this case and categorized them into n number of categories, that led to a wave of criticism. And, we saw our own feminist movements led by Upendra Bakshi and other scholars in Delhi. And that is what led to the Criminal Law Amendment in 1983, wherein the aggravated rape, which is rape by people in authority, for the first time was recognized as a deeper and an independent problem. It was felt that the punishment for rape simpliciter is not sufficient to capture this power dynamics that goes on between the sexes. So when there is a blatant abuse of authority, when there is this power misuse which is there, whereby one gender, because of the positions that they're occupying, they misuse not only their power as a person, but also their official capacity, that, it was felt that we need to have aggravated, we had this definition of aggravated rape. And, we provided punishment for when rape was committed by a policeman, when it was committed by a person who had the control over women, be it as a warden or someone in a hospital. So, we enumerated the situations. But again, the problem was that these were the cases where there was a penetrative sexual assault which was happening. And many times, till the time, so that's the end point, that, there is penetrative sexual assault happening, and then women will have to or should be making the complaints of rape. But what happens prior this, till the act of rape? It is not that one fine day that, yes, there are instances where rapes happen just because she's a woman, she's walking, and, some pervert would just come and, rape her. But rape also happens. There are there are studies that, there is some prior action by the man to hint at the women that, he's desiring her in an illegal manner. For instance, in the ways of stalking, in the ways of making these nasty comments, now following her over her digital presence across platforms, so on and so forth. And that was not an answer which was provided in the law. And you know what? It was only after Nirbhaya happened in 2013 that the criminal law was amended again. So the first, it was amended in 1983 after this Mathura rape incident. And the second time it was amended in 2013, where now we recognize that there might be certain situations, not in all cases, but there might be certain situations where you might have some precursors to the event or to the offense. Event is the wrong word, to the offense of rape, and they need to be separately criminalized. prior to this, we only had one section, which was outraging the modesty of a woman. But the definition, the word itself, outraging the modesty, it was so vague that anything could be brought into it, and even offense, which was just less than penetration, could not be brought under it, depending upon how the judges were thinking. So what happened in 2013 was that sexual harassment, voyeurism, stalking, and disrobing of women, they became offenses in their own regard. At the same time, we recognize that it is not just women who are out there. It is any age. The sexual harassment, sexual offenses can happen even to a child, just one day, who is born of just one day, a girl child, and all the discussion that, women dress outrageously and therefore men rape. You can't justify acts where a girl child of one day is getting raped in our country. So not simultaneously, just a year ago, we had enacted protection of children from sexual offenses, whereby both penetrative as well as non-penetrative sexual offenses were recognized. So it is not always that. And sexual harassment, pornography, all of that were offenses. But the problem with POXO was that it was limited to protecting any child, irrespective of the gender, male, female, or the third category. But the condition was less than 18 years. Women above 18, no protection. So therefore, IPC was amended post Nirbhaya. And, we have this as a criminal law. It's a criminal problem. So I just want to bring home one point, that sexual harassment does not only happen at workplaces. It happens at any place where there is a woman. It will happen where any place she is inhabited. It happens inside the home. It happens outside the home. It happens at any place that, a woman may be visiting. Also, in 1990s, while I started the discourse with, the regressive mindset that our Indian judiciary also portrayed, that our bureaucrats have portrayed, let me point out that it was also recognized in 1990s that sexual harassment is actually impacting the economic freedom that a woman has, and especially in the context of a new economic order that India had opened up in 1991. We realized that yes, these are women who are taking up not only state employment, but who are taking private employment, and they needed to be protected. So, and at the same time, there was a case that had happened, and that was the case of Bhabri Devi, wherein this girl, who was a social worker, she wanted to stop child marriages, and she was, because of the caste issues that were there, when she tried to stop child marriage from happening, the people from the upper caste, when they had to take this revenge, they took this revenge on the body of the women, and they were like, because you are feisty, and you want to stop years of tradition that we have followed, we will teach you a lesson. And the lesson was taught to her in the form of a gang rape. The Sessions Court acquitted the accused. Her appeal is still pending before Rajasthan High Court. If you check the details of the case, 26 years, her appeal has not seen the light of the day. And as this incident happened that shook the nation, there was a public interest litigation which was filed in the Supreme Court. Now, Supreme Court, instead of looking at it as a heinous case of rape, like it did in the RG Care incident, it looked at it from the lens of sexual harassment and what impact it has on working women, because she was a working woman here. And please keep in mind that it was the time when, as I said, India had just followed the path of liberalization. Also, at the international fora, because I was talking about the waves of feminism that had happened, India had ratified CEDAW, which is Convention on Elimination of Discrimination Against Women, all form of discrimination against women. India was a signatory to it, but nothing was done in the country to implement CEDAW. And this NGO then brings up this matter before the Supreme Court. So Supreme Court also recognizes that sexual harassment is a problem, but it cannot create, even the court by its judgment cannot create an offense. It can only interpret the sections. So what it did was, it said, okay, there is CEDAW. This is the problem. We need to find ways to avoid sexual harassment, at least at workplaces. So in 1997, in the famous case of Vishakha versus State of Rajasthan, for the first time, steps were taken to address the problem of sexual harassment, but only at workplaces. It was not addressed holistically, which was done in 2013 by the criminal law. So in 1997, for the first time, the Supreme Court gives binding directions under Article 142 of the Indian Constitution, and we get this internal complaints committee. But because it was a Supreme Court guideline direction, monitoring became very difficult. The listed companies which were there, they perhaps had to declare to the stock exchanges, BSE and NSE, that, these are the number of cases, these are the measures that we have taken for sexual harassment prevention, but not other companies. So it was a patchwork approach. Again, it was better than not having any regulation on sexual harassment, but implementation was tardy. So in 2013, the then government, the UPA government, had introduced this act, which was on the lines of Vishakha Act, which is Sexual Harassment Prevention, Prohibition and Redressal Act, popularly called as the POSH Act. Now, it does three things. I spoke three things, and there are different provisions that addresses it. It talks about preventing sexual harassment in the first place. So it casts duties on the employers to do gender sensitization programs. It creates a duty on the employer to create safe working space. Now, this act is important because now this act is not just limited to the state. Any employer, has 10 working employees, needs to have an ICC, needs to do the steps which are required for preventing sexual harassment. So you need to prevent sexual harassment. Then is you need to prohibit. Now, there is a difference between prevention. Prevention is when the thing has not happened and you are taking steps that it should not occur in the first place. The second is prohibition, that you don't tolerate it as an acceptable behavior. So you prohibit that, this is something which is against our code of conduct. So the definition in POSH of what is sexual harassment is quite wide. It is not only to the incidents that we discussed when we started in the lecture first, but even hostile working place, because I talked about the male gaze and the way they frame laws. At times, they may not be asking for any sexual favor. They may not be making any sexually colored remarks, but they make it so hostile for women. Just because if I'm a woman, they will not grant me work. So indirect ways of sexual harassment. That also, my promotion is denied just because I'm a woman, no other thing. They fear that I'll be on my family way in some time, and therefore, my promotion is denied and stuff like that. So it recognizes hostile working places. It widens the definition of an employee and employer. Recently, a judgment has come from Karnataka High Court on Ola, that whether the person, the passenger, whether she can make a complaint to Ola on sexual harassment, and the High Court has said yes, interpreting the POSH Act. So the definition of an employer and employee, that is quite wide insofar as the POSH Act is concerned. And the definition of the act that constitutes sexual harassment, it's also very wide. I'll take you to the provisions of the act in some time, but let me give an overview. And lastly, it talks about the redressal mechanism. Now, once the So you wanted to prevent, you took your best efforts to prevent, you prohibited it, you don't tolerate it, but it has happened. Despite your best approach, sexual harassment has occurred. Now, how will you redress it? How will you now create a safe space, a safe working space for women? So how complaints have to be made? Within what timeline the complaints have to be answered? Who will be answering those complaints? All those is provided under the redressal mechanism. And herein comes the question that I was asked at the beginning. What if a woman is misusing? There are provisions in the law expressly, if it is found out that the provision is frivolous, then the action can be taken against the women. So this is very broadly the history and the structure in which POSH Act, which is the subject of my discussion today, is. I'll very quickly share my screen and take you to the relevant provisions of the POSH Act. Just hang on for a second. Is my screen visible? So I am not showing you a downloaded version. You can go to indiacode.nic.in. Here you will, it's a repository of all the central and the state laws, the latest versions. So you can download the act from here. It says last updated 3 years ago, no changes have been made. So let's look at, why the act comes into picture, the objectives of the act. It's the dignity of the women, it's the right to equality of the women, which were the reasons. And CEDAW that I talked about, that was the other reason for having this act. Definitely it was a political bait that Congress, the UAPA government had thrown at that time to attract women voters to vote for it. So definitions are wide. I will just take you to the definition of an employee and employer. So employee first. Employee means a person employed at a workplace for any work on regular, temporary, ad hoc or daily wages, either directly or through an agent, including a contractor, with or without the knowledge of principal employer, whether for remuneration or not, or working on a voluntary basis or otherwise, whether the terms of employment are express or employed and includes a co-worker, a contract worker, probationer, trainee, apprentice, or called by any other such name. So the definition of who is an employee is very wide. Then you have employer. Employer, again, the definition is very wide. Wherever, work takes place, even your own internal homes, dwellings, where domestic workers come and, they are employed, even that is covered under the definition of this employer. Then let's look at what is workplace. I'll come to sexual harassment a little later. Let's look at workplace. Workplace is any department, organization, undertaking, establishment, enterprise, so whatever you name it, by government or local authority. The first is covered by them. Government, local authority, government company, corporation, cooperative society. Then we have these private establishments, a private sector organization, private venture, undertaking, enterprise, institution, society, trust, NGO, unit or service provider, anything. The court has now interpreted it even to include an aggregator cab under the definition. That's a workplace. So you have any place visited by an employee, a dwelling place, hospitals or nursing home, everything is included under the definition of workplace. Now, what is sexual harassment? Sexual harassment is one of the following acts: physical contact or advances, demand or request for sexual favors. So even where physical contact has not happened, but a request for it when it's an unwelcome thing. See, one thing that you need to note is that it is unwelcome, meaning thereby that the other person is not reciprocating. Making sexually colored remarks, showing pornography, or any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. Also important to look at this subsection 3.
Pardon, ma'am, it is not visible, ma'am. The act is not visible. Only the URL is visible. The act is not visible. for us.
Okay, I'm so sorry. You should have prompted me again. I'll just reshare my screen. Just give me a second.
Okay.
Is it visible now?
Yes, yes, ma'am. Right now it is visible.
You should have prompted me.
Yes,
Okay.
no problem.
Okay. So prevention of sexual harassment. So as I talked about, even hostile treatment is covered. Where will you find that? That's under section 3, subsection 2. The following circumstances, among other circumstances, if it occurs or is present in relation to or connected with any act or behavior of sexual harassment, may amount to sexual harassment. Implied or explicit promise of preferential treatment in her employment, detrimental treatment in her employment, future employment status, interference with her work, or creating an intimidating or offensive or hostile working environment for her, humiliating treatment likely to affect her health or safety. So when any of these activities are concerned along with an act that the lady is trying to say that it is sexual harassment, then it has to be seen in conjunction. See, at times you can't see an act in isolation. You have to see it in the circumstances, in the background in which it occurred. That is what the act is trying to talk about. So every employer needs to have an ICC, and ICC has to be presided over by a woman, a senior woman at the workplace. It needs to have internal members and external members also. An ICC without external members is no ICC. So they have to be selected, and there has to be a notification of ICC at the workplace that this is the ICC, this is the complaint mechanism, this is how you make the complaint. If the employer has less than 10 employees, then ICC is not mandatory. Then district level, there are local committees. Unfortunately, the state has not established local level committees. Not all districts have local level committees. There is a study which was done on the same. Now, a complaint can be made by of the sexual harassment in ICC or the local committee, as the case may be, by the women, but it has to be in the form of a writing. A written complaint needs to be made within 3 months. Now, please understand. So the fact that you are trying to say if it is for vendetta or for other purpose, under IPC, if you look and you read that IPC with Limitation Act, it's not 3 months. It's a higher time. But here it has to be within the period of 90 days from the date of incident. And one of the reasons why many Me Too movements have failed in the past is because of this 3 months clause. They're like, okay, but the act happened long ago. We cannot take cognizance now. Unlike US and other Western countries, where when Me Too movements happened, they made special acts to say that for this, there will be a waiver of this period of limitation. India has, on the other hand, provided for a period of limitation, which is very less. Why I'm saying it is very less? Because one, for women to understand that the act is sexual harassment, it takes time. Secondly, as I talked about patriarchy, it's very difficult for women to come up, especially if women are the only working members of their home. They would want, there is no job protection. Just yesterday, I was reading the news of a TCS employee being terminated because she made a complaint and, didn't go ahead with it, prosecuted. So women, for raising their voice, the fact that they need courage, the fact that they need support, and they're sidelined then in the workplace because everyone is like the attitude, no, you made a complaint, मेरे साथ काम करोगी, मेरे में भी तुम complaint करोगी, मैं तुम्हारे साथ काम नहीं करना चाहता. So that kind of attitude happens. Therefore, women take time to open up. But law does not recognize that natural fact, and it says 3 months from the date of incident. And it provides for then inquiry into the complaint. It provides for conciliation. If you don't want to go for termination, then conciliation. But in the interim, when the inquiry is going on, ICC has the power to take certain interim measures, and these interim measures can be saying that there be a safe space. Let the delinquent employee and the complainant be not in touch. So no contact policies can be established. If the situation is grievous, the employee can be suspended pending inquiry. So there are mechanisms. There is a express provision, action pending inquiry. Inquiry report is then made, given to the employer, and the employer will then take action as per the disciplinary rules which are there. And to answer the question that I was asked, what happens if it is malicious? Then ICC will have to examine it from that angle also. And if it comes to conclusion that it is malicious or false, then action will be taken against the woman who has made the complaint. And that's largely the structure of the POSH Act. It's not a very heavy legislation. I've just tried to take you through some important provisions. You can perhaps have a look at it. I will also very quickly take you to the new avatar of IPC, which is your Bharatiya Nagrik Suraksha Sanhita. Sorry, Bharatiya Nyaya Sanhita, not Nagrik Suraksha. Bharatiya Nyaya Sanhita, wherein we will talk about these offenses. They are same as under IPC. So sexual harassment is now an offense under Section 75. Punishment is 1 year. Voyeurism is an offense. Punishment is 3 years minimum, maximum 7 years. Voyeurism is when you watch women in doing private act or when their body parts are exposed. That's voyeurism. Stalking also is an offense, as I talked about. So this is by and large, the situation. Again, disrobing that I talked about earlier, that is also an offense where criminal force is used to disrobe the woman. And you definitely have a section on rape, which has a prescribed punishment, a higher punishment for aggravated rape. So that's by and large the legal structure on sexual harassment. Can it stop sexual harassment? No, unless and until each one of us talks about what sexual harassment is, recognizes that it is a problem, it will not stop. So what you need is awareness and understanding that this is a pernicious problem that women face day in and day out. With that said, I'll stop here. If there are questions, I can take them maybe in the next 10 minutes. I'm just reading the comment. Can you please speak in Hindi? I'm sorry, the lecture is already over. I would have spoken in Hindi had I been alerted earlier. I'm so sorry about that. Any questions, concerns, please go ahead.
Kavita Sahara, RDES NGO, who had a message. Please, can you speak in Hindi, ma'am? So is it Kavita Sahara to speak in Hindi? So you may ask questions, ma'am. You may ask question to the speaker. In Hindi also, no problem. In Hindi also, you can ask question, no problem. If you are not able to, if you are not fluent in English language, you may ask question in Hindi as well.
मैं हिंदी में आंसर कर सकती हूँ. आप प्लीज पूछ के जो भी आपका सवाल है उसका जवाब हिंदी में मैं दे सकती हूँ. हिंदी और इंग्लिश के सिवाय मुझे दूसरी भाषा नहीं, कोई तीसरी भाषा नहीं आती है, बट आप पूछ सकते हैं. आपका कमेंट
आप बेंगलोर में रहता था ना मैम? आप बेंगलोर में रहता था ना मैम? कितना साल आप बेंगलोर में रहता था? कितना साल आप बेंगलोर में रहता? 3 years. ओके ओके. नमस्ते
सर, मैं कविता हूँ, सहारा एनजीओ से. हम कर्नाटक में बीदर डिस्ट्रिक्ट में रहते हैं सर.
ओके ओके. आप पूछिए. आप जो पूछना चाहते हैं पूछ लीजिए मैम. जो आपका पास प्रश्न है तो पूछ लीजिए.
सर,
मैम है
हमारे एनजीओ अभी नया है, 7 years हुआ सर स्टार्ट होके. हमारे एनजीओ में हम वुमेन्स डेवलपमेंट, वुमेन्स एम्पावरमेंट और चाइल्ड डेवलपमेंट के लिए काम करते हैं. और हमारे एनजीओ में वुमेन्स के लिए पॉश पॉलिसी का एक कर लिए है सर, और चाइल्ड प्रोटेक्शन पॉलिसी भी कर लिए है सर.
ठीक है. आप मैडम से पूछना चाहते हैं तो पूछ लीजिए. मैडम से क्या पूछना चाहते हो? ठीक, हाँ बोलिए.
एक बार मैडम जी ने कहा है ना सर, वो सब कुछ हमें एक बार हिंदी में।
हिंदी में आपको एक कांटेक्ट नंबर हम दे देंगे। उसमें आपको हिंदी में पूरा शिक्षा दे देगा। आप कुछ ना कुछ प्रश्न पूछना चाहे अभी पूछ सकते हो तो पूछ लीजिए मैम।
कैसे मिला?
कविता जी, आपके एनजीओ में कितने लोग काम करते हैं?
हम 10 मेंबर्स थे मैम।
आपके एनजीओ में इंटरनल कंप्लेंट कमेटी है?
नहीं है मैम।
तो बनाइए ना, वही तो मैंने बोला, अगर 10 या 10 से ज्यादा लोग आप काम करते हैं तो इंटरनल कंप्लेंट कमेटी बनाइए।
जी
मैम
मैम।
जो इंटरनल कंप्लेंट कमिटी है वो जरूरी है, मैंडेट है।
जब
सब कंपनी में
अगर आप
होना
एनजीओ
चाहिए।
भी है ना, एनजीओ भी आपको लगता है कि आप सिर्फ अपना टाइम दे रही हैं, पैसा नहीं मिल रहा है, या आप लोगों की सेवा के लिए हैं, तो ये वो भी आपका वर्क प्लेस है। यही मैं बात आपको बोलने की कोशिश कर रही हूँ कि जो वर्क प्लेस की डेफिनेशन है, कार्यस्थल की जो परिभाषा है, वो बहुत ही वाइड है। आप किसी टैक्सी में जाती हैं, वो बोलता है कि अरे टैक्सी तो कैब एग्रीगेटर है, यहाँ पे मैं जो मर्जी करूँ, ऐसा नहीं चलता है। आप कहीं पे भी जाएंगी वर्क प्लेस पे, अगर आपको फील्ड ट्रिप पे भेजा जाए, होटल में भेजा जाए, वहां हमें कहीं पे भी आप जाएंगे अगर अपने काम के सिलसिले में, तो ये एम्प्लॉयर की जरूरत, जो आपको एम्प्लॉय है आपका, सॉरी एम्प्लॉयर है जिसने आपको नौकरी दी है, उसकी जिम्मेदारी है कि कहीं पे भी आपको वो भेजें तो वो आपको जो आपकी सेफ्टी है, जो आपकी सुरक्षा है, और आपके साथ ये बुरा बर्ताव, सेक्सुअल हैरेसमेंट नहीं होना चाहिए। अगर होता है कहीं पे भी, कोई भी थर्ड पार्टी करे, चाहे साथ वाला कोलीग क्यों ना करे, तो आप कंप्लेंट कर सकती हैं। ठीक
जी
है?
मैम। जी मैम।
मैडम,
हाँ जी सर।
एक क्वेश्चन पूछ सकता हूँ?
जी बोलिए।
ये क्वेश्चन ये है, हम लोग रिसेंटली सुना है वन फॉरगॉटन हर नेम नर्स, शी वाज बीन रेप्ड एंड शी डेड आफ्टर सो मेनी इयर्स विथ
अरुणा शानभाग।
yes, yes, Aruna Shambho, I think so. Correct. Now, you see the person who has raped her, okay, she has been released, he has been released after 7 years, I think so. 7 years of punishment. How come this judiciary is balancing the victim, how much she faced throughout her life? The person who got punishment is hardly a 7 years, I think so. How come the judiciary is balancing this
सर, ये
punishment?
जो आप
The question.
जुडिशियल डिस्क्रिशन की बात कर रहे हो ना, बहुत सारे केसेस में पनिशमेंट बहुत कम दिया जाता था। मैं आपको एग्जांपल देती हूँ। यहाँ तो आप 7 साल की बात करें ना, कई रेप ऑफेंसेस में पनिशमेंट कितना दिया गया है, जब तक कोर्ट उठती नहीं है, टिल द राइजिंग ऑफ द कोर्ट, इतना भी पनिशमेंट दिया गया है रेप के केसेस में।
But this is
कन्विक्शन
to
किया।
change, no, madam. This
ये
is to be changed, no? I mean, maximum of the
अभी
rape
मैं
cases.
अभी इस एटीट्यूड को बहुत स्टडी हुआ कि ये बहुत गलत होता है। वही मैं आपको जो बोल रही हूँ ना, कि जो जज है वो भी मेल है, उसको लगता है हाँ रेप तो है बट ठीक है यार, ये तो चलता है। ये वाला जो
No,
एटीट्यूड है ना बहुत सारे जजेस का, ये बहुत
madam,
गलत था। तो अब लेजिस्लेचर ने क्या किया है, अब मैंडेटरी मिनिमम सेंटेंसेस कर दिए हैं कि
madam,
अगर
madam,
आपने, हाँ जी,
madam, let me interrupt here. Let me interrupt here. I agree with you. There will be a bias if the judge is a male judge. I agree with you definitely. But the books, rules, what is written, that is not biased. Now, whether the judge may be a male or female,
सर
whatever that
जहाँ
may
पे,
be. The book, what is written, the
इसीलिए
thing, what is
अब मेरी
argued.
बात तो सुनिए। आपका
हाँ जी.
सवाल है, वो सवाल तब तक सही था जब तक डिस्क्रिशन थी जज को कि वो कोई भी पनिशमेंट दे सकता है। मैक्सिमम लाइफ इम्प्रिजनमेंट है, या मैक्सिमम रेप के लिए पहले सजा थी आई थिंक 10 साल थी, कि मैक्सिमम 10 साल थी। ठीक है, आप रेप अगर किसी ने किया मैक्सिमम 10 साल है। मिनिमम कितना है उतना प्रिस्क्राइब नहीं था कानून में। लेकिन अब कानून ने क्या किया, उन्होंने रियलाइज किया कि कोई जज जो है वो 2 साल की दे रहा है, कोई 10 साल की दे रहा है, कोई 5 साल की दे रहा है, कोई 7 साल की दे रहा है तो सारे ऑफेंसेस रेप के ही हैं। तो अब क्या किया है, अब प्रावधान ये है कि मैंडेटरी मिनिमम है कि आपने किसी भी सर्कमस्टांसिस में किया हो, अगर एक बार आ गया कि ये रेप है, तो मिनिमम आपको 7 साल की सजा होगी, और मैक्सिमम जो है वो आपको 15 साल की हो सकती है, उम्र कैद हो सकती है। और जो आपने एग्जाम्पल लिया, जो वेजिटेटिव स्टेट है, वो उसी कारण, उसी इंस्टेंस के कारण जो है वो आज रिकॉग्नाइज किया गया कि इसके लिए सजा और ज्यादा होनी चाहिए। तो अब उन्होंने लिख दिया है कि इसका, इस तो अगर वेजिटेटिव स्टेट में लेडी चली जाती है तो इसकी जो सजा है वो मिनिमम लाइफ इम्प्रिजनमेंट है, और लाइफ इम्प्रिजनमेंट का भी मतलब कि मिनिमम 20 ईयर्स, उससे पहले वो जेल से नहीं आ सकता। तो अगर आप चाहें तो मैं आपको बहुत क्विकली रेप की एटलीस्ट जो है वो मैं आपको सजा दिखा देती हूँ। अब जो है 2013 के बाद ये पॉसिबल नहीं है। ये जो आपने एग्जाम्पल लिया वो 2013 से पहले का है। अभी देखते हैं, ये रेप है, रेप सेक्शन 64 में डिफाइंड है और 65 में इसकी पनिशमेंट है। मैं सिर्फ पनिशमेंट वाले सेक्शन पे जा रही हूँ बिकॉज आपका कंसर्न पनिशमेंट का है। देखिए यहाँ पे, whoever commits rape on a woman under 16 years shall be punished with a recurrent imprisonment for a term which shall not be less than 20 years but which may extend to imprisonment for life। तो मैंडेटरी मिनिमम पनिशमेंट्स जो हैं वो अब हैं। हर, अगर आप हर एग्जाम्पल पढ़ेंगे रेप का, वहां पे अब मैंडेटरी मिनिमम है। तो जो आपने एग्जाम्पल लिया अरुणा शानबाग का, वो आज कवर होता है सेक्शन 66 में बीएनएस के। whoever commits an offense punishable under subsection 1 or subsection 2 of section 64 and in course of such commission inflicts an injury which causes death of a woman or causes the woman to be in persistent vegetative state shall be punished with a rigorous imprisonment for a term which shall not be less than 20 years but which may extend to life, which shall mean imprisonment for the remainder of that person's life or with the death। तो अब जो है वो पनिशमेंट बहुत ज्यादा कर दी गई है। अब ये जो डिस्क्रिशन की बात है वो अब छीन ली गई है जजेस से। लेकिन ये जो मैंडेटरी मिनिमम है, इनका अलग से क्रिटिसिज्म होता है। बहुत सारे लोग ये कहते हैं कि मैंडेटरी मिनिमम आने के कारण, कानून को सख्त करने के कारण, ये जरूरी नहीं है कि रेप का जो ऑफेंस है वो नहीं होगा। रेप को या सेक्सुअल हैरेसमेंट को प्रिवेंट करने के लिए क्या चाहिए? देखिए, क्रिमिनल लॉ तो बहुत इजी तरीका है कि अगर आपने किया आपको ये पनिशमेंट है। लेकिन मैंने एज अ स्टेट क्या किया सेक्सुअल हैरेसमेंट को रोकने के लिए? क्या मैंने लाइटें लगाई? क्या मैंने लोगों को जागरूक किया? मैंने नहीं किया। तो इसीलिए जब तक हम जागरूकता नहीं फैलाएंगे, जब तक हम एक सेफ वर्किंग स्पेस नहीं क्रिएट करेंगे, सेफ स्पेसेस क्रिएट नहीं करेंगे विमेन के लिए, तब तक ये ऑफेंसेस होते रहेंगे। तो बहुत क्रिटिसिज्म है कि ठीक है, कानून तो आपका स्ट्रिक्ट है लेकिन कानून की इम्प्लीमेंटेशन स्ट्रिक्ट नहीं है। और स्ट्रिक्टनेस होने का मतलब ये नहीं है कि आपकी और कोई जिम्मेदारी नहीं बनती है। आपकी और भी बहुत सारी जिम्मेदारियां हैं जिसको आपको निर्वह करना है। और लाइटिंग होना, सीसीटीवी कैमरा होना, ये पेट्रोलिंग होना, लोगों में जानकारी देना, ये कुछ महत्वपूर्ण चीजें हैं जो सरकार को करनी है, जो वो नहीं करती है। ठीक है, और कोई सवाल किसी और का? हमारे पास 2 ही मिनट और हैं।
Last question, ma'am. Last question. What is your opinion regarding with the consensual acts of the co-employees who are, loving each other? Thereafter, they will dispute among themselves and raise a complaint.
Very good question, पुरुषोत्तम जी। कंसेंशुअल रिलेशनशिप होते हैं वर्क प्लेसेस पे, कॉलेजेस में। ऐसा नहीं होगा कि आपके जो बैच में थे उनमें कोई एक ऐसा कपल नहीं होगा जिसकी शादी ना हुई हो। होता है ना, कॉलेज में भी होता है, एम्प्लॉय में भी होता है। और कई बार क्या होता है कि उनका फिर रिश्ता टूट जाता है एंड देन दे लेवल द कंप्लेंट ऑफ सेक्सुअल हैरेसमेंट। वहां पे एम्प्लॉय के लिए बहुत दिक्कत वाली चीज हो जाती है। इसका कोई आंसर तो नहीं है कि ये सेक्सुअल हैरेसमेंट हो सकता है या नहीं हो सकता। अगर कंसेंट है तो वो सेक्सुअल हैरेसमेंट नहीं है, पहली बात। एम्प्लॉय जो है वो इन्वेस्टिगेट करेगा। लेकिन बहुत सारे एम्प्लॉयज इंक्लूडिंग योर यूनिवर्सिटी ऑफ ऑक्सफोर्ड हैव मेड इट मैंडेटरी कि अगर आपका किसी को एम्प्लॉय के साथ रिलेशनशिप है तो प्लीज आप उसे पब्लिक करिए। प्लीज आप हमें उसको इन्फॉर्म करिए कि आप इसके साथ कंसेंशुअल रिलेशनशिप में हैं। कई लोग, इंडिया में ऐसा कोई प्रावधान नहीं है दैट यू हैव टू मैंडेटरीली इन्फॉर्म योर एम्प्लॉयर, बट इट माइट बी अ गुड प्रैक्टिस टू डू दैट so as to avoid any situation, any problem in future.
Okay.
Right?
Okay, so thank you so much, ma'am. It was a very fantastic deliberations by your end. This is where local people who are more of the local residents who know Kannada language, but anyway, you have taken up the our other language, this Hindi language, which is a very familiar language to among all. And we have understood many of the things we have understood the basic things, particularly what exactly the sexual harassment, the definition, the scope of the sexual harassment, and the internal complaints committee, and the employers and employees issue, the punishment aspect, and the judicial discretion. All these things that you have clearly, make us understand the concept of the prevention of sexual harassment at workplace. We definitely get back to you, ma'am. If there are any queries, we will mail to you. We'll write a mail to you, and if it requires, we will call you again for another deliberations, ma'am. Thank you so much for the wonderful session, ma'am. It was really enlightening, and we are very much eager to see you, to hear you, how a Supreme Court advocate give a session. All these things that we are very much eager to listen you, ma'am. Thank you so much, ma'am. Thank you so much.
Thank you. My pleasure.
So you may leave, ma'am. ಸೊ ನೋಡಿ, ಸೆಕ್ಷುಯಲ್ ಹರಾಸ್ಮೆಂಟ್ ಅಟ್ ವರ್ಕ್ ಪ್ಲೇಸ್ ವಿಚಾರವಾಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವಕೀಲರು ಇವತ್ತು ನಮ್ಮ ಜೊತೆಗೆ ಮಾತಾಡಿದ್ರು. ಎಷ್ಟು ಚೆನ್ನಾಗಿ ಹೇಳಿದ್ರು ಅಂತಂದ್ರೆ, ಸೆಕ್ಷುಯಲ್ ಹರಾಸ್ಮೆಂಟ್ ಅದನ್ನ ಅರ್ಥನ ಮರೆದು ತಿಳ್ಕೊಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. ಸೊ ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಸೆಕ್ಷುಯಲ್ ಹರಾಸ್ಮೆಂಟ್ ಅಟ್ ವರ್ಕ್ ಪ್ಲೇಸ್ ಅದು ಸಾಮಾಜಿಕ ಒಂದು ಪಿಡುಗು ಆಗಿದ್ದು, ಅದು ಎಲ್ಲ ಕಡೆ ಇರ್ತದೆ. ನೀವು ಯಾವುದೇ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ, ಯಾವುದೇ ಇಲಾಖೆಗಳು ತಗೊಳ್ಳಿ, ಯಾವುದೇ ಒಂದು ಕಂಪನಿಗಳ ತಗೊಳ್ಳೋ ಅಂತ ಸಂದರ್ಭ, ಅದು ಪ್ರೈವೇಟ್ ಆಗಿರ್ಬೋದು, ಪಬ್ಲಿಕ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಗಿರ್ಬೋದು, ಇವನ್ ಯೂನಿವರ್ಸಿಟೀಸು, ಕಾಲೇಜ್ ಲೆವೆಲ್ ಅಲ್ಲಿ ಎಲ್ಲಾ ಕಡೆ ಇರುವಂತ ಒಂದು ಸಾಮಾಜಿಕ ಪಿಡುಗಾಗಿದ್ದು, ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಕಮ್ಯುನಿಟಿ ಲೆವೆಲ್ ಅಲ್ಲಿ ಆ ಒಂದು ಆ ಸ್ಪೇಸ್ ಅನ್ನ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಆ ಮಹಿಳೆಗೆ ಒಂದು ವಾತಾವರಣ ಒಂದು ಕ್ರಿಯೇಟ್ ಮಾಡ್ಕೊಳ್ಳುವಂತ ಜವಾಬ್ದಾರಿ ಪ್ರತಿಯೊಬ್ಬರ ಮೇಲೂ ಇರ್ತದೆ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಈ ಒಂದು ಪೋಷ್ ಕಾಯ್ದೆ ಏನಿದೆ, ಆ ಪೋಷ್ ಕಾಯ್ದೆಯನ್ನ ತುಂಬಾ ಸಾಮಾನ್ಯ ಕಾಯ್ದೆ ಇದು, ಆದ್ರೆ ಸಾಕಷ್ಟು ಎಫೆಕ್ಟ್ ಕೊಡುವಂತ ಕಾಯ್ದೆ ಆಗಿದ್ದು, ಅದನ್ನ ನಾವೇನಂತ ಕರಿತೀವಿ ಅಂತಂದ್ರೆ ಸಾಮಾಜಿಕ ಕಾನೂನು ಅಂತ ನಾವು ಕರಿತೀವಿ. ಸೊ ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಆ ಪೋಷ್ ಆಕ್ಟ್ ಬಗ್ಗೆ ಇಷ್ಟೊತ್ತು ನಮ್ಮ ಜೊತೆಗೆ ಸಾಕಷ್ಟು ವಿಚಾರಗಳನ್ನ ಹಂಚ್ಕೊಂಡ್ರು. ತುಂಬಾ ಅವರು ಬ್ಯುಸಿ ಇರ್ತಾರೆ, ಸಾಕಷ್ಟು ಮೀಟಿಂಗ್ ಗಳಲ್ಲಿ. ನೋಡಿ, 8 o'clock ಅಂದಿದ ತಕ್ಷಣ 8 o'clock ಅವ್ರೀಗ ಹೊರಗಡೆ ಹೋಗ್ಬಿಟ್ರು. ಸೊ ಮೀಟಿಂಗ್ ಇಂದ ಹೊರಗಡೆ ಹೋದ್ರೆ, ಯಾಕೆಂದ್ರೆ ಬೇರೆ ಬೇರೆ ಕಮಿಟ್ಮೆಂಟ್ಸ್ ಇರುವಂತದ್ದು, ಬೇರೆ ಬೇರೆ ಎಂಗೇಜ್ಮೆಂಟ್ಸ್, ಮೀಟಿಂಗ್ಸ್ ಇರೋ ಕಾರಣದಿಂದ ಅವರು ಇಷ್ಟು ನಾವು ಕೇಳ್ಕೊಂಡ್ವಿ, ಬನ್ನಿ ನಮ್ಮ ಒಂದು ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಬನ್ನಿ, ವುಮೆನ್ ಎಂಪವರ್ಮೆಂಟ್ ಪ್ರೋಗ್ರಾಮ್ಗೆ ಅಂದಾಗ ತುಂಬಾ ಮನಸ್ಸಿಂದ ಬಂದ್ರು. ಸೊ ತುಂಬಾ ಭಾರತದಲ್ಲೇ ನಂಬರ್ 1 ಲಾ ಸ್ಕೂಲ್ ನಲ್ಲಿ ಪ್ರೊಫೆಸರ್ ಆಗಿದ್ದಂಥವ್ರು ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ ವಕೀಲರಾಗಿದ್ದಾರೆ ಅವರು. ಸೊ ಅವ್ರಿಗೆ ತುಂಬಾ ಹೃದಯದ ಒಂದು ಅಭಿನಂದನೆಗಳನ್ನ, ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ಇವತ್ತಿನ ಒಂದು ಕಾರ್ಯಕ್ರಮವನ್ನ ನಾವು ಇಲ್ಲಿ ನಿಲ್ಲಿಸ್ತಾ ಇದೀವಿ. ಧನ್ಯವಾದಗಳು. ಮುಂದಿನ ಒಂದು ಕಾರ್ಯಕ್ರಮ ನಾಳೆ ಸೆಷನ್ ಇರ್ತದೆ, ನಾಳೆ ಕಾರ್ಯಕ್ರಮ ಇರ್ತದೆ. ನಾಳೆ ಕಾರ್ಯಕ್ರಮದ ವಿವರವನ್ನ ಗ್ರೂಪ್ ನಲ್ಲಿ ತಿಳಿಸ್ತಾರೆ. ಧನ್ಯವಾದಗಳು. ಸೊ ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮ ತಮ್ಗೆ ಅರ್ಥ ಆಯ್ತಾ? ಏನಾದ್ರು ಅರ್ಥ ಆಯ್ತಾ? ಕವಿತಾಜಿ ಸಹಾರಾ NGO ಅವರು ಬಂದಿದ್ರು. आप कहाँ से बात कर रहे हैं ಮೇಡಮ್?
ಸರ್, ನಾವು ಕರ್ನಾಟಕದಿಂದಾನೇ ಮಾತಾಡ್ತಾ ಇದ್ದೀವಿ, ಬೀದರ್ ಡಿಸ್ಟಿಕ್ ಇಂದ. ನೀವು ಕನ್ನಡ ನನಗೆ ತುಂಬಾ ಖುಷಿ ಆಯ್ತು ಸರ್.
ಹೌದಾ? ನಿಮ್ಗೆ ಎಲ್ಲಿದು ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದು ಲಿಂಕ್ ಸಿಗ್ತಾ ಇದು? ನಿಮ್ಗೆ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ ತಾವು?
ಹೌದು ಸರ್.
ಓಕೆ ಓಕೆ ಓಕೆ, ಸರಿ ಮ್ಯಾಮ್, ಸರಿ. ನಾವು ನೋಡಿ, ನಮ್ಮ NGO ಕಡೆಯಿಂದನೂ ನಿಮ್ಗೆ ಏನಾದ್ರೂ ಕಾನೂನು ರೀತಿಯಾದಂತ ಸಹಾಯ ಬೇಕಿದ್ರೆ ನಾವು NGOಗಳಿಗೆ, ಮಹಿಳಾ ಸಂಘಟನೆಗಳಿಗೆ ಮತ್ತು ಜನಸಾಮಾನ್ಯರಿಗೆ ಎಲ್ರಿಗೂ ಸಹ ಒಂದು ಕಾನೂನಿನ ಸಹಕಾರವನ್ನ, ಕಾನೂನಿನ ಅರಿವನ್ನ ನಾವು ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ಸೊ ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಏನಾದ್ರೂ ತೊಂದರೆ ಇದ್ದಂತ ಸಂದರ್ಭದಲ್ಲಿ ನಮ್ಮ ಹತ್ರ ಮುಕ್ತವಾಗಿ ತಾವು ಮಾತಾಡಿದಂತ ಸಂದರ್ಭದಲ್ಲಿ ನಮ್ಮ ಕೈಲಿ ಎಷ್ಟು ಸಾಧ್ಯ ಆಗುತ್ತೋ ಅಷ್ಟು ತಮ್ಗೆ ಸಹಾಯವನ್ನ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ, ಯಾರಾದ್ರೂ ಇವತ್ತಿನ ಒಂದು ತರಗತಿ ನೋಡಿ, ಇವತ್ತು ಅವರಿಗೆ ಕನ್ನಡ ಬರೋದಿಲ್ಲ, ಬಟ್ ಆದ್ರೆ ಯಾಕೆ ಕರ್ಸಿದ್ವಿ ಅಂತಂದ್ರೆ, ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಬೇಕು, ನಮ್ಮ ಒಂದು ಆಲೋಚನೆಯ ಒಂದು ಏನು ಫ್ರೀಕ್ವೆನ್ಸಿ ಇರುತ್ತೆ ಅದು ದೊಡ್ಡದಾಗ್ಬೇಕು. ಸೊ ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಒಬ್ರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವಕೀಲರು ಬಂದು ಮಾತಾಡ್ತಿದ್ದಾಗ ನಮ್ಗೆ ನಮ್ಮ ಒಂದು ಏನು ಥಿಂಕಿಂಗ್ ಲೆವೆಲ್ ಏನಾಗ್ತದೆ ತುಂಬಾ ದೊಡ್ಡದಾಗ್ತದೆ. ಸೊ ಈ ನಿಟ್ಟಿನಲ್ಲಿ ನಮ್ಗೆ ಇಷ್ಟು ಮಟ್ಟದ ಒಂದು ಕಾನೂನಲ್ಲಿ ಇಷ್ಟೆಲ್ಲ ಒಂದು ಸ್ಕೋಪ್ ಇದೆಯಾ, ಇಷ್ಟೆಲ್ಲ ಒಂದು ಅನುಕೂಲ ಇದೆಯಾ? ಒಬ್ಬ ಲಾಯರ್ ಆದಂತ ಸಂದರ್ಭದಲ್ಲಿ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಲಾಯರ್ ಆದಂತ ಸಂದರ್ಭದಲ್ಲಿ ಈ ರೀತಿಯಾದಂತಹ ಗೌರವ ಆಧಾರಗಳೆಲ್ಲ ಸಿಗ್ತದ, ಈ ರೀತಿಯಾದಂತೆಲ್ಲ ಆಲೋಚನೆ ಈ ಮಟ್ಟದ ಇರ್ತದ ಅಂತ ಅನ್ನೋದೆಲ್ಲ ವಿಚಾರ ನಮ್ಗೆ ತಿಳಿತು ಅಂತ ನಾನು ಭಾವಿಸ್ತೀನಿ. ಸೊ ಮುಂದಿನ ತರಗತಿಯನ್ನ ನಮ್ಗೆ ನಾನು ಮತ್ತೆ ಹೇಳ್ತೀನಿ. ಸೊ ಇವತ್ತಿನ ಒಂದು ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ತಾವೆಲ್ಲ ಬಂದಿರೋದ್ರಿಂದ ಎಲ್ರಿಗೂ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೀನಿ. ಧನ್ಯವಾದಗಳು. ನಮಸ್ಕಾರ.
ಹಲೋ ಸರ್. ಸರ್
ನಾವು ಹೇಳಿ.
ನನ್ನ ಮಗಳು ಲಾ ಮಾಡ್ತಾ ಇದ್ದಾಳೆ ಸರ್. ಕೆಲವೊಂದು ಅವಳಿಗೆ ಹೆಲ್ಪ್ ಆಗೋದಿದ್ರೆ ಮೇಡಮ್ ಅವ್ರ ನಂಬರ್ ಸೆಂಡ್ ಮಾಡಿರ್ತೀರಾ ಅಂತ.
ನಾನು ಅವ್ರು ಕೇಳ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಕು. ಅವ್ರು ಕೇಳ್ಬಿಟ್ಟು ಮಾಡ್ತೀವಿ. ಸೊ ಲಾ ಅವ್ರಿಗೆ ಕೇಳಿ ತಮ್ಗೆ ನಂಬರ್ಗಳನ್ನ ಕಳಿಸ್ಕೊಡ್ತೀವಿ. ಆಯ್ತಾ?
ಸರಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್. ಮಾತಾಡಿ
ಸರ್. ಕರಿಬಸಪ್ಪ ಅಂತ ಹೇಳಿ ಹರಪನಹಳ್ಳಿಯಿಂದ, ವಿಜಯನಗರ ಡಿಸ್ಟಿಕ್. ತುಂಬಾ ಚೆನ್ನಾಗಿತ್ತು ಸರ್ ಇವತ್ತು ಮೇಡಮ್ ಅವ್ರ ಕ್ಲಾಸ್. ಬಟ್ ಕನ್ನಡದಲ್ಲೇ ಆಗಿರೋದ್ರು ಕೂಡ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಈಗ ಕಲೀಲಿಕ್ಕೆ ಒಂದಿಷ್ಟು ಪ್ರಯತ್ನ ಪಡ್ತಾ ಇದೀವಿ, ತಿಳ್ಕೊಳಕ್ಕೆ ಮಾಡಕ್ಕೆ. ಚೆನ್ನಾಗಿ ಮಾತಾಡಿದಾರೆ. BNS ಆಕ್ಟ್ ಬಗ್ಗೆ ಅದ್ರ ಇವತ್ತಿನ ಮಹಿಳೆಯರಿಗೆ ಇನ್ನೀಗ ಏನೆಲ್ಲ ಇತ್ತು ಅನ್ನೋದು ಇನ್ನೊಂಚೂರು ಎಕ್ಸ್ಪ್ಲೇನ್.
ಅಲ್ಲ, ಅವರು ಏನ್ ಹೇಳ್ತಾ ಇದ್ರು ಅಂತಂದ್ರೆ, ಈಗ ನ್ಯಾಯಾಧೀಶರು ಗಂಡಸರಿದ್ದು ಮತ್ತು ಅವ್ರಿಗೆ ಒಂದು ವಿವೇಚನಾತ್ಮಕ ಒಂದು ಶಕ್ತಿ ಇದ್ದು, ಸೊ ಆ ಪೇಟ್ರಿಯಾರ್ಕಲ್ ಮೈಂಡ್ ಸೆಟ್ ಅಲ್ಲಿ ಶಿಕ್ಷೆಯ ಪ್ರಮಾಣವನ್ನ ಕಡಿಮೆ ಕೊಡುವಂತ ಸಾಧ್ಯತೆ ಇದ್ದು, ಕಾನೂನಿನ ನಿಟ್ಟಿನಲ್ಲಿ ಕಾನೂನೇ ಮಾರ್ಪಾಡು ಮಾಡಿ ಕಾನೂನಿನಲ್ಲಿ ಅದನ್ನ ಇಷ್ಟು ವರ್ಷ ಶಿಕ್ಷೆ ಕೊಡ್ಲೇಬೇಕು ಅಂತ ಮ್ಯಾಂಡೇಟ್ ಮಾಡಿದಾಗ, ಸೊ ಆ ಸಂದರ್ಭದಲ್ಲಿ ನ್ಯಾಯ ಸಿಗುತ್ತೆ ಅಂತ. ನಾನು ಸಂಜೆ ಒಬ್ರು ನನಗೆ ಕರೆಯನ್ನ ಮಾಡಿ ನಾನು ಕೇಳ್ತೀನಿ, ಈ ವುಮನ್ ಎಂಪವರ್ಮೆಂಟ್ ಪ್ರೋಗ್ರಾಮ್, ನಾವೇನ್ ಮಹಿಳಾ ಸಬಲೀಕರಣ ಕಾರ್ಯಕ್ರಮವನ್ನ ಮಾಡ್ತಾ ಇದೀವಲ್ಲ, ಸೊ ಈ ನಿಟ್ಟಿನಲ್ಲಿ ತಮ್ಗೆ ಅನುಕೂಲ ಆಗ್ತಾ ಇದೆಯಾ ಈ ಕಾನೂನುಗಳಿಂದ ಏನಾದ್ರು ಅನುಕೂಲ ಆಗ್ತಾ ಇದೆಯಾ ಅಂದಾಗ ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಿದಾಗ ನಾನು ಅವ್ರು ಒಂದ್ ಮಾತು ಹೇಳ್ತಾರೆ, ಸಮಾಧಾನ ಇದೆ, ಕಾನೂನು ಇದೆ ಅಂತ ಸಮಾಧಾನ ಇದೆ, ಆದ್ರೆ ನಾವು ಸಂಪೂರ್ಣವಾಗಿ ಬಲಿಷ್ಠರಾಗಿಲ್ಲ, ಸಂಪೂರ್ಣವಾಗಿ ಕಾನೂನು ಅಷ್ಟು ನಮ್ಗೆ ಒಂದು ಸಪೋರ್ಟ್ ಅನ್ನ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಒಂದು ಬೇಸರವನ್ನ ವ್ಯಕ್ತಪಡಿಸ್ತಾರೆ. ಅಂದ್ರೆ ಕಾನೂನು ಬರೀ ಪೇಪರ್ ನಲ್ಲಿ ಇದೆ, ಆದರೆ ವಾಸ್ತವದಲ್ಲಿ ಕಾನೂನು ಹೆಚ್ಚು ಮಹಿಳೆಯರನ್ನ ಶಕ್ತರನ್ನಾಗಿ ಮಾಡ್ಬೇಕು. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಅಧಿಕಾರಿಗಳಿರ್ಬೋದು, ಸರ್ಕಾರದ ಅಧಿಕಾರಿಗಳಿರ್ಬೋದು, ವ್ಯವಸ್ಥೆ ಇರ್ಬೋದು. ಸೊ ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಅವ್ರಿಗೆ ಸರಿಯಾದಂತ ನ್ಯಾಯವನ್ನ ಒದಗಿಸ್ಕೊಟ್ಟಂತ ಸಂದರ್ಭದಲ್ಲಿ ಆ ಕಾನೂನು ಏನಿರ್ತದೆ ಆ ಕಾನೂನಿಗೆ ಒಂದು ಮಹತ್ವ ಬರ್ತದೆ. ಕೇವಲ ಕಾನೂನು ಪುಸ್ತಕದಲ್ಲಿದ್ದು ಅದು ಇಂಪ್ಲಿಮೆಂಟೇಶನ್ ಆಗ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಯಾವುದೇ ತರ ಮೌಲ್ಯ ಇರೋದಿಲ್ಲ. ಇಷ್ಟೋ ಸಲ ನಾವು ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ಮಾಡ್ತಾ ಇರ್ಬೇಕಾದ್ರೆ ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳ್ತೀವಿ, ಕಾನೂನು ಅಂದ್ರೆ ಏನು ಅಂತ ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಿದಾಗ ಒಂದು ಯಾವುದೋ ಒಂದು ಕಾರ್ಯಕ್ರಮ, ಆ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಒಬ್ರು ಅಂಗವಿಕಲೆ ಹೇಳ್ತಾರೆ, ಕಾನೂನು ವಾಟ್ ಇಸ್ ಲಾ ಅಂತ ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಿದ್ರೆ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಕಾನೂನು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕಾನೂನು ಅಂದ್ರೆ ನ್ಯಾಯ ಅಂತ ಅಂದ್ಬಿಡ್ತಾರೆ. ವಾಟ್ ಇಸ್ ಲಾ ಅಂತಂದ್ರೆ ಲಾ ಮೀನ್ಸ್ ಜಸ್ಟಿಸ್ ಅಂತ. ಸೊ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಂಡಿದ್ದೇನು, ಕಾನೂನು ಅಂತಂದ್ರೆ ಸೆಟ್ ಆಫ್ ರೂಲ್ಸ್ ಅಂಡ್ ರೆಗ್ಯುಲೇಷನ್ ಅಂತ. ಒಬ್ಬ ಚೇತನ ಅನುಭವಿಸ್ತಾರಂತ ಹೆಣ್ಮಗಳು ಹೇಳ್ತಾಳೆ, ಕಾನೂನು ಅಂತಂದ್ರೆ ನ್ಯಾಯ ಅಂತ ಹೇಳಿ. ಸೊ ಅದು ನಿಜವಾದ ಅರ್ಥ ಅಂತ ಅನ್ಸುತ್ತೆ, ಕಾನೂನು ಅಂತಂದ್ರೆ ನ್ಯಾಯ ಅಂತ ಹೇಳಿ. ಸೊ ಆ ನ್ಯಾಯದ ದೊರಕದಾಗ ಮಾತ್ರ ಆ ಕಾನೂನಿಗೆ ನಿಜವಾದಂತಹ ಒಂದು ಮೌಲ್ಯ ಬರ್ತದೆ, ಅದಕ್ಕೊಂದು ನಿಜವಾದಂತಹ ತೂಕ ಬರ್ತದೆ ಅಂತ ಹೇಳ್ತಾ, ನಮಗೆ ಅಟ್ಲೀಸ್ಟ್ ಕಾನೂನುಗಳಾದ್ರೂ ಇದೆಯೇ ನಮ್ಮನ್ನ ಸಪೋರ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅನ್ನೋ ಒಂದು ಭರವಸೆ ತಂದ್ಕೊಡುತ್ತೆ. ಅಷ್ಟು ಜನಕ್ಕೆ ಆ ಭರವಸೆಯ ಒಂದು ದಾರಿನೂ ಸಹ ಗೊತ್ತಿಲ್ಲ. ಕಾನೂನಿನ ಅರಿವು, ಮೇಡಮ್ ಹೇಳ್ತಾ ಇದ್ರು, ಅವೇರ್ನೆಸ್ ಇಸ್ ವೆರಿ ಮಚ್ ರಿಕ್ವೈರ್ಡ್ ಅಂತ ಹೇಳಿ, ಅವೇರ್ನೆಸ್ ಇಸ್ ದ ಕೀ ಅಂತ ಹೇಳ್ತಿದ್ರು. ಸೊ ದಟ್ ಈಸ್ ಅರಿವು ಅನ್ನೋದು ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟು. ಅದರಲ್ಲೂ ಕಾನೂನು ಅರಿವು ಇದೆಯಲ್ಲ ಅದು ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್. ಅಟ್ಲೀಸ್ಟ್ ನಾನು ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತೀನಿ ನೋಡು ಅಂತಂದ್ರೆ, ಯಾರು ತೊಂದರೆಯನ್ನ ಕೊಡ್ತಾ ಇರ್ತಾನೆ ಅವನು ಅಲ್ಲಿಗೆ ಸ್ವಲ್ಪ ಹಿಂದೆ ಮುಂದೆ ಯೋಚನೆ ಮಾಡಕ್ ಶುರು ಮಾಡ್ತಾನೆ. ಅಟ್ಲೀಸ್ಟ್ ನನ್ನ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಆಗ್ಬಿಟ್ರೆ ನಾನು ಜೈಲ್ಗೆ ಹೋಗ್ಬಿಡ್ತೀನಲ್ಲ ಅನ್ನೋ ಒಂದು ಭಯ ಇರುತ್ತೆ. ಸೊ ಆ ಮಟ್ಟಕ್ಕಾದ್ರೂ ನಮ್ಮನ್ನ ಕಾನೂನು ರಕ್ಷಣೆ ಮಾಡ್ತಾ ಇದೆ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ನಾವು ಕಾನೂನನ್ನ ಗೌರವಿಸ್ಬೇಕಾಗತ್ತೆ, ಕಾನೂನನ್ನ ಅರ್ಥಕೋಬೇಕಾಗುತ್ತೆ, ಕಾನೂನನ್ನ ಫಾಲೋ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ನಾವು ಕಾನೂನನ್ನ ರಕ್ಷಣೆಯನ್ನ ಮಾಡಿದ್ರೆ, ನಾವು ಕಾನೂನನ್ನ ಅರ್ಥಕೊಂಡ್ರೆ ಆ ಸಂದರ್ಭದಲ್ಲಿ ಕಾನೂನು ನಮ್ಮನ್ನ ರಕ್ಷಣೆ ಮಾಡುತ್ತೆ ಅಂತ. ಧರ್ಮೋ ರಕ್ಷಿತಿ ರಕ್ಷಿತ ಅಂತ ಹೇಳ್ತಿದ್ರಲ್ಲ, ಸೊ ಹಾಗೆ ಕಾನೂನನ್ನ ನಾವು ರಕ್ಷಣೆಯನ್ನ ಮಾಡ್ಬೇಕು, ನಾವು ಪೋಷಣೆಯನ್ನ ಮಾಡ್ಬೇಕು. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಅದು ನಮ್ಮನ್ನ ಕಾಪಾಡುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇವತ್ತಿನ ಒಂದು ತರಗತಿಯನ್ನ ನಾನು ಇವತ್ತು ಇಲ್ಲಿಗೆ ನಿಲ್ಲಿಸ್ತಾ ಇದ್ದೀನಿ. ಮತ್ತೆ ನಾವು ಭೇಟಿಯಾಗೋಣ ಮುಂದಿನ ಸಂಚಿಕೆಯಲ್ಲಿ, ಮುಂದಿನ ಒಂದು ಹೊಸ ವಿಷಯದಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ಎಲ್ರಿಗೂ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತಾ ಇದ್ದೀನಿ. ನಮಸ್ಕಾರ.